Hi, Assalamualaikum. I'm Nadratul and this is my group mates. This is Akid, Darwish, Adriana and Armin. So in this question, there is two legal issue. The first legal issue will be discussed by me, Akid and Adriana. And the second legal issue will be discussed by Armin and Darwish. So the first legal issue is whether the letter posted by Dr. Morhan is considered as an acceptance that can force the contract to be bound.
So I will be answering the law for the first legal issue. So according to section 2 subsection B, if an offer is made by the offeror and the offeree agrees and accept the offer, then there is an acceptance to such offer. And next, section 4 subsection 2 paragraph A and also paragraph B provide for the communication of the acceptance where there is a gap of time between the communication or acceptance by the acceptor and the receiving of that communication by the proposer. With regard to the postal communication and telegraph, acceptance is complete upon posting or dispatching of the telegram. This rule is known as the postal rule and is an exception to the general rule that the acceptance is only complete when it is communicated. In the case of Adams and Linksell, the court held that the offer had been accepted as soon as the letter had been posted. Thus, it was indeed a contract in existence before the sale of the wool to the third party, even though the letter had not actually been received by the defendant. The defendant was therefore liable in breach of contract. Next, in the case of Ignatius and Bell, the court held that the party had contemplated the use of the post as a means of communication. The acceptance was complete as against the offeror when it is put in the course of transmission to him so as to be out of the power of the offeree. Lastly, in the case of household fire and carriage accidents insurance and grants, the court principle is that if the letter was lost in the post, the offeror is still bound in the contract although he did not receive the letter of acceptance.
So, just now, our member Adriana just discussed about the legal issue and the law that consists in our research that we had been analysis. And today I'm going to discuss about the application. Okay, we move on according to section 2 subsection B. Above it define the definition of acceptance which relates to this case. From the perspective which the offer has been made by Aman towards Dr. Mohan, as whether Dr. Mohan is interested in buying his car for Rm 40,000. Then Dr. Mohan agreed at the offer that been made against him. Therefore, they are the acceptance to such offer made by Dr. Mohan. Meanwhile, according to section 4 subsection 2 para A and para B, this section explains about when the communication is complete. Legally, with regards to the postal rule, the communication will complete upon posting or dispatching the telegram. This postal rule is an exception for the general rule, which communication will be complete after the acceptance comes to the knowledge of the offerer. By the virtue of this case, it shows that Aman has posted his offer letter through the course of transmission, which the postal rule applied. Meanwhile, Dr. Mohan has agreed the letter 6 days after the offer made against him. Since he is using the postal letter method, the moment he posted his letter as his acceptance to the offer in the course of transmission, it shows the result for him to be bound by the contract and the agreement immediately enforceable by law. Next, this case could be referred on the case of Adams v. Lancel, which this case after when the defendant Lancel and Company decided to sell some wool to the Adams and Company. On September 2, Lancel and Company received the offer letter and decided to accept it. They promptly drafted an acceptance letter and posted it on the same days. Unfortunately, the acceptance letter took several days to reach the defendant, arriving on September 9, even though it was properly posted on September 5 and September 8 after not receiving response from the plaintiff. The defendant assumed the offer had been declined and sold the wool to someone else. And upon receiving the plaintiff acceptance letter on September 9, the defendant refused to proceed with the transaction, stating that they had already sold the wool to another buyer. The court held that they were they are a binding contract. To apply in this case, there are a lot of similarities. The central issue in this case was whether the contract was formed when the plaintiff posted their acceptance through the course of transmission. On September 6, the case of Ahmad and Dr. Mohan could be concluded by establishing the poster rule itself, holding that acceptance by post becomes effective when the letter is properly posted, not when it is received. Therefore, the contract between Ahmad and Dr. Mohan was deemed to be formed on 6 days after the offer executed, which is when Dr. Mohan posted the acceptance. Next is by referring the second case, the case of household fire and carriage accident insurance versus Grant, which the defendant Mr. Grant applied for shares in the complainant's company. The household fire notice of the allotment. However, this letter never reached Mr. Grant and it was lost in the post. Mr. Grant never paid for the shares as a consequence when the household fire insurance company went bankrupt. The liquidator asked the defendant for payment of the shares. Mr. Grant refused to pay as he did not believe he was a shareholder, nor was there a binding contract in his mind. The court held that there are binding contract between these two parties since the letter was posted in the course of transmission. Comparing to this case, there are no big difference between the refer case and the case of Ahmad and Dr. Mohan, since both of the material facts shows they are bound in contract, although he did not receive the letter of acceptance. Dr. Mohan has posted the letter in the course of telegram as he was agreed with the offer. In addition, Ahmad assumed that his offer already been cancelled and gave his car to his sons. Furthermore, the letter he posted lost somewhere else, contradict to what the postal rule has extended. The acceptance been posted through the course of transmission, the contract was constituted to be valid. Therefore, this is the reason why even though the letter posted by Dr. Mohan get lost somewhere, the contract is still binding. For conclusion, to conclude all of this, the letter has been posted by Dr. Mohan can be considered as an acceptance that enforces a valid contract between them. That's all for me. Thank you.
Okay, now I will explain to you the second situation from the case, which is the issue between Aman and Kasim. So for the first legal issue, we found that the legal issue is whether Daniel's insertion of the new clause 4A with entirely new terms constituted a counteroffer. The law is, according to Section 2B of the Contracts Act 1950, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted when one party makes an offer to another party and the second party agrees to the terms of the offer. It means that they signify their acceptance. There is no definite definition for acceptance. However, there are some cases that can interpret the meaning of acceptance. For example, in the case of Bekalan Sains PNC Sedang Berhad and Bank Bumiputra Malaysia Sedang Berhad, when Judge Blackham stated that acceptance means a person is bound whatever a man's real intention may be, if a reasonable man would believe that he was assenting to the terms proposed by the other party and that other party upon that belief enters into contract between him. Section 7A of the Contracts Act 1915 stated that acceptance must be absolute and unqualified. There shall be no addition, subtraction or modification in the terms of the offer to determine whether the parties had reached consensus at idem or what we can call meeting of the minds. The objective test is compulsory. This principle can be seen in the case of Dutch Bank Malaysia Berhad and MBF Holding Berhad. Finally, in the case of Hyde and Ranch, the court held that there is no existing contract between both parties as the plaintiff changed the condition made by defendant. Thus, it became a counteroffer.
In the application and the conclusion of our tutorial 2, tutorial question 2. So, according to section 2B of the Contract Act 1950, it defines what is the definition of acceptance related to this case. In the case above, Daniel check 10,000 as a deposit to buy Kasim property that value RM 100,000 ringgit. But Kasim rejected the new clause 4A that being added by Daniel in SPA. Then Kasim withdrew the draft of the SPA and returned back the check RM 10,000 ringgit. And this is considered as no acceptance by definition of section 2B of the Contract Act 1950. By virtue of the case Bekalan Sains PNC Sdn Bhd against Bank Bumi-Putra Sdn Bhd, Kasim action of withdrawal draft of SPA and return the check back to the Daniel signifies Kasim as a reasonable man that did not want assenting to the term proposed by the other party, which is Daniel, and Kasim did not believe to enter to contract with Daniel. According to section 7A, explain that acceptance must be absolute and unqualified. And this case when Daniel made some modification by adding clause 4A that giving Daniel wide power of attorney, including power of conversion and subdivision of Kasim land, as well as its management, improvement and development, other than removal of caveats and delivery of document. But Kasim reject the new clause that modified by Daniel, which is clause 4A. This proof there is no acceptance because there is modification of the term that not being agreed by Kasim, and this term is not absolute. By virtue of the case Dutch Bank against MBF Holding Sdn Bhd, Kasim and Daniel as both parties did not reach consensus ad idem on the term in the offer and failed the objective test, which is compulsory. When Kasim rejected the offer by conduct of withdrawal of SPA and return the check RM 10,000 ringgit to Daniel, we can relate they are not consensus ad idem on the terms by the conduct of the Kasim reject, which is they fail the objective test, which is compulsory, that has been stated by in the case of Dutch Bank Malaysia Berhad against MBF Holding Berhad. So, in another case of Hyde against Ranch, I will explain the background of the case. June 6, defendant offered to sell his farm to the plaintiff for £10,000 sterling. In June 8, plaintiff made a counter offer of £915 sterling. In the June 27, plaintiff wrote again offering to pay £10,000 sterling, but defendant refused, and the plaintiff sued for specific performance. And then the court decided that by making counter offer, the plaintiff have rejected the original offer. There was no valid binding contract between parties. By relating case of Hyde against Ranch, in this case, there are a lot of similarities. This can be related when Daniel modified the SPA by adding new clause 4A. Is considered as making counter offer and Kasim reject it. So there is no valid binding contract between both parties. Conclusion: Daniel insertion of new clause 4A, which entirely new term constitute as counter offer, and the original offer has been rejected. So there is no binding contract between them. Thank you guys.